Welcome to the Forever Cash Life Real Estate Investing Podcast with your hosts, Jack and Michelle Bosch. Together, let's uncover the secrets to building true wealth through real estate and living a purpose-driven life.
Hey there, everyone. Jack Bosch speaking here, and welcome to one other episode of our Winning Wednesday session here. Welcome to our show. I'm super excited to have you guys here today. We're going to do an Ask Jack Anything kind of session. So as you chime in here, please make sure you put in your questions right into the chat box on any kind of subject around land flipping, real estate, entrepreneurship, and things like that. So what I'm going to today, and in the meantime, while people are coming in here and asking a question, I'm going to cover a few subjects. And one of them is, again, the subject that I think I covered a few times in the last few weeks is that of title issues and how to solve them, right? Well, obviously, there's a few ways that you can solve title issues. I looked through our Facebook group here, the Land Profit Generator Real Estate Investing Facebook group, and there's one session from Priscilla that says, like, talk to a very motivated seller who wants to sell like yesterday. His wife's brother gave the property, and he's just have been paying the taxes for the last 20 years. However, he's now in long-term rehab, and the husband has the power of attorney. The property owner, the brother, is deceased. He's never been married and doesn't have children. So does the property still have to go to probate? How to handle this? Well, here's what you need to look at. Who owns in any kind of title issue that you look at? Really, the way to go about that is they asking a few questions. And the asking the questions is, number one, who owns the property? Well, in this case, who owns the property? It's the brother, the property owner. And the property owner has been deceased as of 9 years ago, right? And he was on top of it living in Germany. Coincidence, I'm from Germany, if you guys know. So, but there's living in Germany at the time of his death. Doesn't really matter where he died. What matters is that he's no longer alive. So the owner is no longer alive. The owner apparently has no heir, no children, has never been married, doesn't have children. But the owner has a brother. Okay, so the brother seems to be, in this case, the only heir. So what that means is that, and for more information about it, is his wife's brother gave her the property, and he has, or his wife's brother. So therefore, it's basically the person that passed away is the wife's brother. So the wife is the only heir, right? And the wife is now in long-term rehab, and there's a husband and wife. The wife is the sister of the person who is the property owner. So the owner passed away. The sister now has been paying property taxes. The sister is now in rehab. So her husband has a power of attorney. Does this need to go to probate? Well, that's a great question. And the answer is a very, very clear, absolutely yes. And it's very, very simple. Who owns the property? The deceased person. When a person passes away and leaves property behind, that property doesn't just pass on to the heirs without probate. You need probate, period. Doesn't matter if the sister is now in rehab or the husband of the sister has the power of attorney. Those are all auxiliary kind of information. The main information is the person who owned the property died, and he did, and it looks like that. And so the first answer is, if the person dies and leaves property behind, probate is necessary. Point blank, done. Question answered. Now, however, it's open the next layer of questions. And the next layer of questions is, how did he own the property? So if he owned the property in a trust, and the sister was a trustee of that trust. Let's say, like, you and your spouse, you have a trust, right? Let's say you have put a property in a land trust. Right? Land trust, you can download land trust for $20 from different websites. You can go to an attorney for a couple $100. They can give you a land trust. So you put the property in a land trust. So now who is the owner? The land trust is the owner. Who controls the land trust? The trustee of the land trust. And who is the owner of the land trust? The beneficiary of the land trust. The beneficiary is the owner. The trustee is the one that controls the land trust. Okay? So therefore, what needs to happen is if this is a situation, and I'm just saying like if this would be the case, if this owner would have had this property in a land trust with his sister being the successor trustee and also the successor beneficiary of that trust, then when he passes away, the ownership of the property didn't change. Because even though he passed away, who owned the property? The trust owned the property. So in that case, what happens is the successor trustee steps in, and the successor trustee can now sign for the trust. And who would be the successor trustee? Who, in this case, if the brother and sister did that with each other, then it's the sister. By the way, if in that scenario, if that property, since that property never changed ownership, there's actually also, and I'm not an attorney, nor do I play one on television, so check with your attorneys on it. But there's actually a probate benefit for that, because since the property really didn't change ownership, the property is still owned by the trust, but only the trustee and the beneficiary changed, and then this property is actually not subject to any kind of inheritance tax, any kind of death tax. So therefore, you can avoid probate here, and potentially you can avoid paying taxes on that thing. Now, usually there's like by inheriting things, right now you can inherit up to like $11 million without having to pay taxes on it if you do it the right way. And even though Biden right now wants to remove that and put that back down to $1.5 million, it's still within well above what most people inherit. So taxes are not really an issue, but probate is an issue. The process of probate can be avoided by that because the property did not change ownership. It's continued to be owned by the trust. So this post by Priscilla did not specify how the property was owned. It just said that the person that passed away was the property owner. So as a result, we will assume there was no trust involved. But this person could have, and that's a tip for you, even for your own properties, even for your own house for that matter. You can put your own house into a land trust, right? Into a trust, and then declare your children, your benefit, the successor beneficiaries, and the successor trustees, so that when you pass away, guess what? Your children now can legally sign and sell that house, right? Can legally sign and sell the house without having to take it to probate. So there's some probate benefits of working with trust. Now, I'm not a trust expert. You got to look out for trust experts. You can Google them. You can find them out there, and there's information about that. But bottom line is there is information about up there, and that would change the thing. So if this would have been owned in a trust, and the sister would have been the successor trustee, then you would have basically simply worked with the sister, or in this case with the husband of the sister, because the husband now has the power of attorney for the sister. So a power of attorney is another concept I want to quickly explain, because a power of attorney really means that you are stepping, if you have the power of attorney for your spouse, that means that you can sign on her behalf. In other words, it almost means that you can step legally into her shoes and sign as if it was her by having that legal power of attorney. Right? That's what a power of attorney means. So by him having the power of attorney for his spouse, because she's in long-term rehab, he can then sign for her. And if she's the trustee of the trust, then he can sign in his capacity of power of attorney for his spouse as the trustee of the trust. And that would work. But that only works if there's a trust. Obviously, in this scenario, it doesn't look like there's a trust. So therefore, the answer in this scenario was the owner owned it. He passed away. His sister has been paying property taxes for 20 years. His sister has been using the property for 20 years. His sister does not own the property. He still owns the property even though he's deceased. So therefore, there's necessary for probate to happen. So let's go one step further though. There's actually, well, how do you do the probate in that case? You do the probate in this case by looking in that state and see, and Priscilla, that's what she would need to do. She would need to look at is there what's called a small estate probate process in that state. So states like California, Arizona, New Mexico, other states have what's called a small estate probate process, which is basically the full-blown probate process costs you $2,500, $3,000 with an attorney. They need to fill out a bunch of paperwork. I need to file a probate filing with the court, and then the court takes sometimes 6 months to look at it, or usually 2 to 3 months to look at it, and all kinds of stuff needs to happen. Well, and then the probate is done, the judgment is done, and now the property passes from the deceased one to the heirs. Well, there is in many states, there's something that's called a small estate probate process. In the small estate probate process, you have usually what's a three-page affidavit, right? A 3-page affidavit, or affidavit of heirship, affidavit of succession, or a small estate probate form. And when you use that document, you basically fill it out as the heir. Like the heir needs to fill it out themselves. Legally, you can't help the heir to fill it out. Now, could you technically, if nobody knows about it? Yes, but that's not a recommendation. You basically, but as the buyer here, as one of our students, what you do as one of our land profit generator students, you basically get that document, send it to the buyer, send it to the seller, and have them fill it out. It's usually an easy to fill out form. They sign and notarize it, and then you help them. It's getting filed at the court typically, but usually there's just one person that is authorized, that's not a judge, to literally look at it, check it, stamp it, and then send it back to you. Usually there's a fee between $200 and $400 involved for that. And then so you accompany the fee with it, and then they stamp it, they send it back. Now you record that in the county, and the probate is done. So it's a very much faster way. Basically, in essence, the courts in the United States, because it's such a litigious, however you say that, country, so it's so easy to sue somebody, that the courts are overwhelmed with lawsuits. So what a lot of states and counties have done is they have put those small estate probate things in place that where they basically say like, hey, if it's an estate under X amount of dollars, usually that's around the $25,000 to $75,000 range. Different states have different rules. We're not going to go mess with it. Nobody's going to go fight over a piece of land and an old car and perhaps some furniture in the house, right? So let's just, if the kids, the heirs, are clear about who should be getting what, then very simply they can just fill out this 3-page form. They swear that in the document that this is the truth and nothing but the truth, and so on, and therefore they fill this out. Say like, I'm the heir. I certify that I'm the heir. That there's no other heir. Fill it out. They submit it in, pay the $200 to $400. A week later, sometimes 2 to 6 weeks later, depending on the bureaucracy of that particular county, you get it back, stamped and executed. You record it, and now the transfer of ownership has happened. It's a fast way to do it. Now, in this particular case, that Priscilla brought on, right? This Priscilla brought on, where she said, I'm going to read it one more time in case you came in late to the session. Talked to a very motivated seller who wants to sell like yesterday, and he and his wife are in their early 90s. His wife's brother gave the property, and she has just been paying taxes for the last 20 years. So in this particular case, we identified that the property is still owned by the deceased person, and it does require probate. However, there's another way also that this seller could obtain ownership to it. And they could also obtain ownership by what's called an adverse possession process, or by a quiet title process. And both of these processes, what they effectively mean is that you file a lawsuit that basically says, listen, I've paid property. The adverse possession is where she says, listen, I've paid taxes for 20 years on his properties. I've used the property. I've blatantly used the property. I have been the one mowing the lawn. I've been the one having barbecues on here. I've been being the one putting a fence around it, if she has done those things. I've been the one paying property taxes. Therefore, I have taken possession of this properties. And in the United States, there's usually an adverse possession law that says that if somebody blatantly, publicly does that for 5 years, they can go claim ownership of that property. All right, so then they file a lawsuit, file a suit in the court. Court looks at it, looks at the evidence, and then say, okay, great, that's true. You have done all of this. You showed the evidence. Nobody complains about it. We'll give you ownership of that property. Right. The second way you can do that is also through the quiet title suit. You can say, hey, listen, guys, I want to file a quiet title suit here to the court. And what that does is that says, hey, there is a property that rightfully belongs to me because I'm the only heir, and it's not being used. It's sitting out there. There's nobody else that has a right in it. I would like to become the owner of it. Here's the birth certificate thing. It shows that I'm the brother of this person. Please give that property to me. So in a quiet title suit, you have to put advertising out there in some newspapers, and nowadays also online. You have to do a little bit diligent search to see if there's indeed no children for the person that passed away. If there's indeed no other heirs. And then you present that, and usually an attorney does that. You present that to the court, and then when the court looks at that, they're like, okay, great, there's no heirs, there's nothing. Also, all your diligent search showed that you did all the proper steps. There's nobody else that is stepping forward. Yes, we'll give you the property. Right? And that's what's called a quiet title suit. So in other words, there's, as I said, there's multiple ways to solve this right now here. The easiest way, but the easiest way is to go to probate, and it does need some probate, or the adverse possession. Those seem to be the easiest ways in this case. Now, again, can you avoid all of that? Even for your own life, guys, is yes, put stuff like that into trusts. Have a family trust. Talk to a trust attorney. If you have some assets to protect, put them in a trust. Right, and go to a trust attorney. The first time we went to a trust attorney, the trust attorney charged us $3,000 to set up a basic trust for us. Our daughter was just born, Sophia, right? We just basically said we have built some assets through land flipping, right? We had flipped a couple $1,000 lots already at that time. We had just started buying single families also for rental purposes. So we went to the attorney, says like, hey, I think it's time for us to do some asset planning here to protect our assets, and also make sure that if we get hit by a truck someday, that there's no probate issues and our daughter doesn't have to pay all these things. So and what comes in there is that when you do a proper trust, they're going to talk to you about, for example, medical powers of attorney. What happens if you have an accident and you're on life support and you're in a coma? Are you going to want them to pull the plug on you, or they want you to keep you awake for like alive artificially forever? Those are questions you want to ask yourself, but these are side questions, right? Other things you want to do, you want to talk. So they're going to do power of attorneys. Who is going to be your power of attorney in case certain XYZ things come in case you're in rehab, or you're incapacitated? Who can sign for you? Then also, who is your successor trustee? Who you trust that if you pass away is going to take care of these assets? Now, if you have children and you trust those children, then you can put those in place. Then also, who you put in as your successor beneficiaries. Beneficiary is the owner of the trust. So if you pass away, who becomes the owner of those assets ultimately? And the nice part is, if you do it the right way, you can avoid all this probate stuff. Now, obviously, there's a limit to it because you're still inheriting property up to, so whatever those legal limits are before you have to pay taxes, they still apply. But if you're planning to inherit $1 million down the road to your kids, right, because you're making great money with land flipping, then you might want to put this into a trust. And then as your assets grow, now you do this, you're one of the rock stars, which, for example, we have a comment here from Chad Hees that says, hey, this post is long overdue. Thank you, your coach, as well as Jack and Michelle, for creating an amazing system. We just completed a full year of coaching and closed our biggest deal ever yesterday, netting us $135,000 after all costs and commissions. And this was one deal. We actually closed 2 deals. Another one made $5,000. And then we made and then another one is an escrow that will get us result in monthly payments of $350 for the next 5 months. Yes, that's all profit since the buyer's down payment covered the cost of acquiring the lot. So far, we've closed 9 deals with net profits of $230,000. Boom, right? And about $50,000 of that will come in next in the form of payments. And those payments will total about $1,400 a month, and so on and so forth. So if you're like, now they're going into scaling mode, right? And because they made $230,000 in their first year in coaching, so they're possibly going to make $750,000 in this next year. Who knows, right? They're going to make $1 million in the 3rd year. Like at that point, you do want to put things in place, because guess what? Chad, let me look at his profile picture. He doesn't look old. Like he looks like a young person here. So as a result, he has another 30, 40 years of being able to do massive real estate deals, and he might retire, and he might go and pass away a centimillionaire, right? He might retire a centimillionaire, and all started by our land flipping. Isn't that exciting? I love that stuff. So when he does, you don't want to just leave behind $1 million, $5 million, $10 million, $100 million without any proper protection, and all of a sudden your heirs have to pay taxes through their noses, right? Don't give everything to Uncle Sam. Protect yourself. So I know I started with this session here from Priscilla and everything, but it brought us more into the asset protection kind of world. But sometimes that happens, and that's actually fine, because again, real estate, there's two sides of it. There's playing offense and making a ton of money, and there's playing defense and making sure that the assets and the cash and the income you generated are actually protected from predators, are protected from the IRS, are protected from the government for death taxes and things like that. So make sure you actually, as you grow in your real estate business, you start paying attention to both things. At the beginning, only offense matters. Go create a huge freaking mess of profits. Create hundreds of thousands of dollars of profits, but once you do that, as you're in the process of doing that, then make sure those assets, those profits, those successes are protected, so that you have you can live that lifestyle forever, and that you can also, when you pass away, that your heirs don't have to pay the price for you not paying attention to those things. So with that said, thank you very much, guys. Have a great rest of the day. I did answer a few questions. So if you have more questions, please just simply come over. If you're watching this on YouTube or so, come over into Facebook, into our Facebook group, Land Profit Generator Real Estate Investing. If you're interested in working with us on coaching and have the results potentially like the gentleman I just talked about, then absolutely go make sure and chat. Then go to landcoaching.com, book yourself a call with us to talk about it. And then with that said, thank you very much. Have a great day, great rest of the day. Thank you. Bye-bye.